court is on the record in City of Conneaut versus Robin Kopech, case number 24 CRB 77. This case is set for a preliminary revocation hearing today. A probation violation complaint was filed against Ms. Kopech on August 5th of 2025. We scheduled a preliminary revocation hearing for August 18th, 2025 at 2:30 p.m. Service of that hearing notice was provided to Ms. Kopech. She failed to appear on August 18th, and so I issued a warrant for her arrest. Ms. Kopech is turning herself in on that outstanding warrant today. Subsequent to that, another probation violation complaint was filed against Ms. Kopech on August 18th, 2025. So we are going to conduct a preliminary revocation hearing on both probation violation complaints filed against her that are pending. Ms. Kopech is present. She's not represented by counsel. Also present is probation officer Sean Benoit. Ms. Kopech, have you received copies of both probation complaints?
Yeah.
I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and understand the nature and the elements of the complaints filed against you. You also have a right to know the potential penalties that could be imposed. Now, in the first complaint filed on...
Welcome back to the courtroom, where the tension is high and the stakes are even higher. Today, we're diving into the case of City of Kia versus Robin Kopech, a woman who's no stranger to this judge's orders. On the table? 2 probation violations. One for skipping mandatory check-ins, and another for something the judge has warned her about before, possession of animals. Yes, you heard that right, animals. And what you're about to see is a fiery exchange where the judge questions her respect for the law, her ability to follow simple orders, and even her honesty in court. Stick around, because this case spirals into shocking admissions, a frustrated probation officer, and a final sentence that leaves everyone on edge. Who's in the wrong here, Robin for repeatedly defying orders, or is the system being too harsh? Let's break it down.
On August 5th, 2025, it's alleged that you failed to maintain contact with adult probation. You failed to report to scheduled appointments on July 30th, 2025, and August 5th, 2025. If you are found to have violated the terms of your probation on this complaint, you do face a maximum 180 days in jail. I've already placed you on the maximum period of 5 years of supervised probation, so I can't extend that any longer, other than on any tolling that might have happened. And or I could impose more restrictive community control sanctions, more restrictive than what I've already done, imposed. So those are the consequences you face if found to have violated your probation on that complaint. Do you understand?
Yes, sir.
On the complaint filed against you on August 18th, 2025, in the same case, which alleges that you were allegedly found in possession of companion animals on August 18th, 2025, in violation of this court's March 27th, 2024 order. You do face up to 180 days in jail. Again, I've already placed you on the maximum period of supervised probation, so I can't extend that. And I could impose more restrictive community control sanctions, more restrictive than what I've already ordered. So do you understand the consequences you face if found to have violated your probation on that complaint?
Yes, sir.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to another hearing, which is called a final revocation hearing. At that final revocation hearing, you would have a right to cross-examine witnesses and to confront evidence presented against you. You would also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. You would also have a right to be proven guilty by a preponderance of the evidence and a right not to testify. You also have a right to have an attorney represent you in this proceeding, and because you are facing jail consequences if convicted of violating your probation, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. And I do find that you have previously been represented by the public defender's office in this case. And if you still qualified, I would reappoint the public defender. You have a right to a continuance of this preliminary revocation hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of having violated your probation in this case, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction. And you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty to this complaint today, I will set your case for another hearing, that being the final revocation hearing, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings. And today you have the right to a reasonable bond. You have two plea options with respect to each of these complaints filed against you. You can either plead guilty or not guilty. If you plead guilty, that is a complete admission by you to the complaint filed. If you plead guilty, the court will find you guilty and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the complaint filed. And as I said earlier, if you plead not guilty, I'll set your case for a final revocation hearing, and I will set a bond. Ms. Kopak, do you have any questions regarding the rights or plea options I've just explained to you?
No, sir.
Officer Benoit, could you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, your position, and the basis for each of the complaints filed against Ms. Kopak in this case.
Yes, sir. My name is Sean Benoit. I'm the City of Conneaut's probation officer. The basis of the complaint was the August 5th, 2025 case. Correction violation is that Ms. Kopak failed to maintain contact with adult probation, failed to report in on the July 30th and August 5th, 2025 appointments. And the August 18th complaint is that Ms. Kopak was found to be in possession of a companion animal against the court's order. Subsequent to a home visit, she had a cat in her dresser drawer.
In where?
In her dresser drawer.
Okay, the court finds probable.
Did you catch that? A cat hidden in a dresser drawer. That's not just bizarre, it's a direct violation of a standing court order. Judges take probation terms seriously, and here, the condition couldn't be clearer: no animals, period. When Robin chose to take in that cat, whether temporary or not, she wasn't just bending the rules, she was openly defying them. And hiding it shows she knew it was wrong. Now, think about this: should compassion for a sick neighbor's pet excuse breaking a court order, or does the law have to be applied strictly to keep order? Drop your thoughts in the comments, this one's controversial.
Probable cause exists for the filing of each of those probation violation complaints. Okay, Ms. Kopak, we will start with the first probation complaint filed against you on August 5th, 2025. Again, that involves the allegations of you failing to report for appointments on July 30th and August 5th and maintain contact with the probation department. How do you plead to that complaint?
Guilty.
To the second complaint, which alleges that you were found in possession of companion animals. This complaint filed on August 18th, 2025. How do you plead?
Guilty.
You understand, Ms. Kopak, by pleading guilty to both of these complaints that you are waiving your right to a final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you. You'd also be waiving your right to subpoena witnesses. You'd be waiving your right to be proven guilty by a preponderance of the evidence, as well as your right to testify or not to testify without any negative connotation. All of those are hearing rights you'd be waiving by pleading guilty to these complaints. Is that what you wish to do?
Yes, sir.
Also, by pleading guilty, you'd be waiving your right to an attorney. You have been represented by counsel throughout this case. By pleading guilty to these complaints, you would be effectively waiving your right to be represented by an attorney as well as being advised by an attorney. Are you sure you want to do that?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
Are you currently on probation, parole, community control, or post-release control with any other court?
No, sir.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to these complaints today?
No, sir.
Are you thinking clearly?
Yes,
Do you
sir.
understand everything that's happening?
Yes, sir.
Do you read and write English for the record?
Yes, sir.
I'm going to provide you a document that's entitled Waiver of Hearing Rights on Probation Violation Cases. If you have any questions regarding that document, please feel free to ask me. If you find it acceptable, you can sign the end date at the bottom. Court finds that the defendant has executed in open court the written waiver of hearing rights. I should put the wrong date on there. I do find the defendant's admissions or plea of guilty to each of the probation violation complaints filed against her in this case to be knowing, voluntary, and intelligent. Court will accept the guilty pleas to both complaints, and I will therefore find her guilty of having violated her probation in this case. I'm now going to proceed to sentencing. Ms. Kopak, is there anything you would like to say before I impose sentence?
No, sir.
Officer Bowing?
Your Honor, I believe a term of incarceration is due at this point. Ms. Kopak has continuously failed to report in for appointments. Has continuously failed to answer the door to residents when we try to conduct home visits. She's maxed out on probation, as already mentioned. I don't know what else to do at this point, Your Honor.
Any response to that, Ms. Kopak?
No, sir.
Ms. Kopak, I just don't understand. Do you just feel like you can do whatever you want? Do you just feel like you're not subject to any court order? Ms. Kopak,
Yes.
you were found in possession of multiple animals in your home at one time in March of 2024 when you were convicted of neglecting terribly these animals. I've ordered you to have no animal in your home. You continue to defy my order. So help me understand. Do you not wish to comply with my court order?
No, sir.
You don't? You don't want to comply with my order?
Oh, yes, sir.
So why do you continue to have animals in your home?
Well, it wasn't my animal.
Here's where the courtroom tension spikes. The judge flat out tells Robin she's been defying orders for over a year, 3 probation violations in just 15 months. That's a pattern, not a mistake. Notice his tone here. It's not just about one cat or a missed appointment. It's about respect for the system. Judges often use this moment to hammer home accountability, especially when past warnings haven't worked. But here's a question for you. Is Robin someone who just can't follow rules, or is she genuinely caught in situations where she feels she has no choice? Think about it, because the judge clearly believes it's the first.
The man had a heart attack, and I just had his cat there to take care of when he was in the hospital.
Where's the cat now?
I don't know.
Do you know?
Dog warden took possession of it, Your Honor.
The dog warden took possession of his animal then.
Yes, sir.
Ms. Kopak, I've ordered you to have no no possession, control, or custody of any animal, any companion animal, dog or cat, whether it's temporary or not, because you don't know how to take care of animals. So help me understand. Do you not care about my order?
Yes, sir, I'm here.
Then why do you continue to defy it? Because this isn't the first time. I sentenced you in March of 2024. A probation violation complaint was filed against you in March of 2025. A year later, you were convicted of violating your probation. Let's find it. On June 2nd of 2025, you pled guilty. I sentenced you and moved you from unsupervised probation to supervised because of your continued defiance to violate my order to not be in possession of animals. That was just in June 2025 when I sentenced you on a probation violation. So now this is your second and third strike. You violated probation 3 times in a year and 3 or 4 months. What do you think I should do with you, Ms. Kopak?
I don't know, sir.
Why don't you keep in contact with Officer Benoit?
I wasn't notified of the right time to be there. He notified me the day I was supposed to be there 10 minutes later.
Why weren't you at court? Why weren't you at court when you're supposed to be in this court on August 18th? Why did I have to issue a warrant for your arrest?
I wasn't aware of the date I was supposed to be here at court.
Really?
Yes.
Was she aware?
She was aware, Your Honor. She texted me at 14:23, and I notified her that she...
Which is 2:23 p.m.
that afternoon that day. Yes, Your Honor.
And the hearing was at 2:30.
Yes, sir, and we held the hearing at 2:45, actually.
So she texted you indicating she was aware of the hearing?
And then she said she was not going to make it and asked me to reschedule.
So are you lying to me, Ms. Kopak?
No, sir.
You texted Officer Benoit before the hearing on August 18th. Do you not remember doing that?
Yes, I did.
So you were aware of the hearing?
Yeah, he notified me 10 minutes after it was over. I've been after him all week to tell me what day.
On August 6th of 2025...
I'm sorry, slow down. I can't understand you.
On August 6th of 2025, I notified Ms. Kopak that she would receive a hearing notice in the mail. She said, okay, got it, thank you. 3 separate texts. She responded to my text on August 11th, said, you simply when? And then she called or texted me the day of the hearing, and that's when I told her you have a hearing this afternoon at 2:24 that afternoon. And she said, I'm not going to make it, I need you to receive. And she was at her residence at that time on 526 Smith Street, and the dog were and saw her and asked her where she was going because she was leaving immediately after that, and she said she was going to the grocery store.
At the time she was supposed to be here?
Your Honor.
You went to the grocery store at the same time you're supposed to be in court. You remember that?
Yes, sir.
Remember telling the dog warden that?
Yes, sir.
Do you not care?
This is jaw-dropping. Robin admits she skipped her court date to go grocery shopping. Let's be real, folks, that excuse doesn't fly. Courts view attendance as non-negotiable. Failing to appear can land you in jail faster than almost any other violation. The fact that she texted probation about it shows she knew, but still prioritized her errands over a judge's order. That's the kind of detail that makes or breaks credibility in the courtroom. So, here's the challenge for you. If you were the judge, would you have believed her explanation, or would you see it as proof she just doesn't take the court seriously?
Care?
I care, sir.
Then why were you here? Why couldn't you come here on the way to the grocery store?
I wasn't aware that I was supposed to be there at that
Oh,
time.
come on, Ms. Kopak.
He called me 10 minutes, he texted me 10 minutes after the court I was supposed to be here.
Ms. Kopak, you don't care about court orders. I'm imposing a 3-day jail sentence. We will give you a jail report date. Our jail is full today. If it wasn't full, I would have you arrested right now and taking you into custody. You continue to defy court orders. More importantly, if you are found to have any more animals in your home because you can't take care of them, do you get that? You can't take care of an animal. Do you understand that?
Yes, sir.
An animal doesn't deserve to be in your care because you can't take care of them. If you are found one more time to be in possession of any companion animal, you will go to jail for the maximum time period. I don't care about your age. I don't care about your condition. We have done everything we can, bent down backwards for you to involve Adult Protective Services and to get some type of investigation going on you. It has all failed, not because of our efforts. We have done everything we can to try to help you, but you thumb your nose at the system, you thumb your nose at the court, you thumb your nose at the orders. One more time, Ms. Kopech, one more time, you'll be spending 6 months. 6 months in the Ashtabula County Jail. You understand?
Yes, sir.
Officer Benoit will give you a 3-day jail sentence. He'll give you a jail report date. I'll suspend the balance of 177 days. All of the other conditions that have been previously imposed will continue. Anything further, Officer
No,
Benoit?
thank you.
Okay, Ms. Kopech, you'll go to the clerk's window and you'll meet with Officer Benoit.
And there it is, Robin Kopech sentenced to 3 days in jail, with the judge making it crystal clear, one more violation, and she'll be looking at 6 months behind bars. This case highlights something bigger. Probation isn't just about second chances, it's about proving you can follow the court's conditions. Fail to do that, and the consequences escalate quickly. Whether it's ignoring appointments, skipping court, or hiding animals in dresser drawers, the message from the bench is clear: defiance has limits. What do you think? Was this sentence fair, or too lenient given her history? Let us know in the comments below. And if you found this breakdown as shocking as we did, hit that like button, share this video with your friends, and don't forget to subscribe for more jaw-dropping courtroom drama and legal insights. Until next time, stay sharp.